taxes. It does not. You're not required to have a tax preparer's license in order to return your own, make your own federal tax returns, for example. So the license to carry is for security professionals to carry a firearm in the performance of their duties to serve the public. It is not a license to bear arms for one's personal use. This is well recognized law since 1943 in Murdoch versus Pennsylvania, where the Supreme Court says a state may not impose a charge for the enjoyment of a right granted by the federal Constitution. A person cannot be compelled to purchase through a license fee or a license tax the privilege freely granted by the Constitution. Thus, states like Massachusetts intentionally misapply these otherwise constitutional laws to the injury and extraction of the Americans within their borders. And it is this great evil we call the color of law today, and which the founders referred to as acts of pretended legislation in a jurisdiction foreign to our Constitution and unacknowledged by our laws. We can't do anything to prevent violations of the Constitution in other states, but the state of New Hampshire needs not unlawful actions of other states, and this legislation is needed to safeguard the rights of the people of this state and to give notice to other states that their illegal practices shall not be aided or abetted within our borders. I'm ready for any question that the legislators would like to ask. Thank you.
Thank you, sir. I understand this issue, and I've seen it happen. I believe in a particularly egregious state might be New Jersey, I think, where people are often run afoul of this issue by traveling to an airport. If they happen to pick up their baggage and have to leave, they're automatically a felon.
Right.
The question I have was, it sounds like you've done some research on this. How do we square the circle of Article 4, Section 1 that says full faith and credit, that part of the Constitution that says we have to honor the court rulings of other states?
For this reason, Your Honor, sir, there are actually two kinds of crimes that people don't generally know about, but it's derivable if you think about it. The first kind of crime is a common law crime that involves an injured party, and the second crime is called a regulatory crime. And the Massachusetts Judicial Court has affirmed on several occasions that, quote, in the context of a statutory analysis, the unlicensed possession of a firearm itself is a regulatory crime. And now, a regulatory crime is by definition enforced by the regulatory agencies. If you look at the States Administrative Procedure Act, Mass General Law 30 Alpha, Section 1 defines a regulations as rules adopted by an agency to implement, to enforce, or to interpret the law administered by it. The fact that these agencies are not made a party and not allowed to be in the court, so to speak, makes that a violation of the State's Administrative Procedure Act, their own State's Administrative Procedure Act, where it says licensing agency has, quote, solely to determine whether the agency shall institute or recommend institute proceedings in a court. And according to their own Declaratory Judgment Act at 231A, Section 8, any proceeding which involves the validity of a license, the licensing agency granting the privilege shall be made a party and shall be entitled to be heard. Now, I can tell you this: when I was going to trial, the person running the show, the magistrate, did not allow the licensing agency to come forth and confer their subject matter jurisdiction of the licensing board. Now, that would be equivalent to me having a problem with my medical license and the county prosecutor prosecuting me for a violation of the Medical Practice Act. If they brought me into a county court, they would have no subject matter jurisdiction unless the medical board who has been vested with that subject matter expertise comes up to the court and confers it to them. So the answer to your question is that It squares with Article 4 because there was no court that was actually convened. If we study this issue very carefully, what we have here is a lack of subject matter jurisdiction before the court. And when that happens, we know that it is a proceeding, quorum non judice, and a nullity under the law. It's many case law and statutes say that, including Federal Rules Civil Procedure number 12 and Mass General laws under the Criminal Code as well. They must have subject matter jurisdiction.
So your position is that we wouldn't be bound by Article 4 because the court ruling wouldn't actually be a court ruling within the meaning of the law. But if we're talking about extradition orders, so the extradition order would presumptively be that you had been charged with a crime in Massachusetts and you did not come to Massachusetts to stand for that crime, and they asked for your extradition from New Hampshire to Massachusetts. Is your position that the order ordering you to come stand before the court not, in your opinion, binding under Article 4? Or just the procedure with which they wish to try you on the firearms charge?
My position is that any charge that is without jurisdiction is without due process, and the state of New Hampshire has a constitutional duty to uphold not only the Constitution but the laws and the due process within its own borders. So, in the very least, I think a person in that situation should be brought before or have an opportunity to go before a New Hampshire judge and say, look, here are the charges, here's why they don't have jurisdiction, and here's why I'm entitled to the protections of this state.
And under the current laws, is it your opinion that you do not have the right to fight extradition?
Under the current laws, you've already been captured and you've already been spent time, possibly weeks or months, in jail. So there's a deprivation of rights before any remedy is due.
See. More of a speedy hearing.
Yes.
Thank you. Any further questions from the members? Yes, Representative Saley.
Thank you, and thank you for taking my question. I'm just curious, do you currently live, I mean, you're talking about charges that happen in Massachusetts.
Correct.
Is in your testimony. Do you live in New Hampshire?
I do. I've been a New Hampshire resident since 2000, circa 4 or 3 or something like that.
Okay, thank
Yeah.
you.
They shouldn't be able to extradite you on it. Representative Meese.
Can you tell us what the current status is of your medical license?
My medical license is clear and active in New Hampshire.
Follow up? Has your medical license been suspended in other states?
Yes, it has. Starting in not in New Hampshire, but Massachusetts, it has.
Follow up?
Follow up, but
But it's
medical
been-
license is really not relevant to this, but go ahead.
It's been fully adjudicated in New Hampshire and in other states, in other jurisdictions as well. But it remains revoked in Massachusetts.
Just to interject, the medical license is often suspended automatically, is it not? If you're suspended in one state, they have an agreement where everyone does it, and then you have to go back and get them all.
Correct. And in this case, New Hampshire did do their adjudication, and they decided that I wasn't a problem.
Thank you.
Yeah.
If you have another question, Representative Meese?
What was the reason for the suspension of your license?
I'm not sure if that
I see.
is relevant to this case, but it had nothing to do with the practice of medicine or any common law crime.
That's good enough. Thank you. Representative Reed.
Mr. Chairman, I don't see how that line of questioning is relevant to the bill we're discussing.
It could have been if it was relative to the crime he was going to be extradited for, but we've already explored it and asked and answered. Any further questions? Representative Pratt, do you have a question? Okay. Anyone else? Seeing no further questions, thank you very much for your testimony, sir.
Thank you very much, sir. Have a good day.
Is there anyone else here wishing to testify on this bill who has not yet testified? Seeing none, I close the public hearing on HB 1035, and I open the public hearing on HB 1404. Yes, I'm sorry. Oh, I didn't realize we went so fast. I gavel the huh? The previous witness? I closed the hearing. Um, we're gonna just be in recess for 10 minutes, okay? And you can 10 o'clock. I open the public hearing on HB 1404 and invite the representative to introduce this bill.
Good morning, members of the committee. Jason Gerhard, representing Franklin Northfield, Merrimack 25. I think it'd be easiest to explain what I was trying to go for with this bill and let you guys decide if that hit the mark or not. The problem in my mind is that there are vindictive prosecutions or prosecutions for crimes that aren't truly crimes where the defendant does not have the opportunity to actually go before a jury of their peers to have them adjudicated. Because certain personal examples, during the whole COVID scare, pandemic, I was arrested for putting anti-mask and vaccine stickers on and around City Hall in Manchester. That case was dropped, but not after a long, drawn-out period of harassment, arrest, and so forth. But even if that case had proceeded to trial, I would have never been able to actually go before members of the public and explain my purpose in doing so, which I think has been vindicated at this point. But I just feel that it's a dangerous precedent to set where people can be arrested for things, and because they're charged at a lower level, you never have the opportunity to actually bring them before people other than government officials, as in judges. And then at that point, you don't even have the ability to argue jury nullification, which I think is a key fact, because that allows you to say, okay, I might have violated this so-called law, but at the same time, this law doesn't comport with the Constitution or simply common sense and so forth. And that's the last paragraph of this bill. Notwithstanding any other provision in this chapter, any and all courts shall accept the introduction by the defendant of any evidence relevant to his or her pro-offered defense, even if such defense is not explicitly recognized by law, and particularly any defense purported by the defendant to be regarding a violation of the New Hampshire Constitution. The defendant shall be entitled to produce all proofs that may be favorable to himself or herself that the defendant believes to be relevant to attempt to persuade the jury to exercise its right of nullification. There are other additional brushes with the law that I've been involved in, including being arrested out front of the governor's house. Well, I'm sorry, that was ticketed, fined. If we had a candlelight vigil, another individual was arrested. This is during the COVID lockdown because the governor was conducting business out of his house, state business. So there was protests held there. And again, that charge was just dropped. But even if it had proceeded to trial, you don't have the opportunity to actually explain what was going on and letting the general public decide if that was a valid cause. So that is the general gist of what I was attempting to go with this. And that's also why on page 2, where you will be afforded a trial for anything over $20. However, there's a caveat in that there will be a fee set at $500 if the defendant is found guilty of the initial charge. And this is to offset people taking every stupid little thing to trial just to slow down the system. Because I understand justice is important to move swiftly, but at the same time, I don't think it should be like McDonald's fast food. I think you need to kind of evaluate each case and figure out if this is demonstrating a larger issue that needs to be addressed, instead of just kind of rubber stamping everything and just pumping people through the system. So that's basically where I was going with it. I'm not sure if it made the point clear, but I'm open to any questions to try to clarify.
Thank you, Representative. So I understand the first principle that you should be allowed a jury trial for just about everything. I mean, exceeding $20. The question I have is are you trying to kind of get 2 bites at the apple here, where you can go ahead and have a judge you elect for a trial by a judge, and then if you don't like the outcome, get a jury trial on the same charge? Or are you saying I should have the option in the first instance to say I'll go with the judge, or I want a jury?
The latter was what I was going for.
One of the two. But
Yes,
not
yes,
one
I don't-
And then say, I don't
yes.
like this, I want the jury now.
Yes.
Okay, thank you. Any further questions from the members? Representative Muse.
I like the way you think with numbers. So as I understand your bill, a defendant who actually loses a case would be charged an additional $500. But if defendant who's exonerated would get $5,000 back?
Yes. The intent is to keep the government from prosecuting people for phony crimes. You should not be getting arrested with a misdemeanor charge, putting a sticker on a garbage can in Manchester that says, don't get vaxxed. Honestly, if I knew now what I knew, I wouldn't. I would put a million more stickers. But anyway,
Would it not make more sense to say if you're exonerated, your attorney fees should be paid for instead of just a blanket $5,000 check to everybody?
the problem is certain people, like the previous gentleman that testified, they're walking lawyers as it is. So
Pro se, they,
yeah, I worry that people that are actually skilled in the law, which I think we need to be more people to do so instead of just giving witch doctor attorneys the power over them. Yeah, if that makes sense. I'm trying to avoid that.
Okay. Representative Selig.
Thank you. I have a concern. So if someone committed a penalty the violation would exceed $20 and they're then found guilty by a jury, you're saying they would need to pay $500. But for people who maybe already have extremely limited means, wouldn't that punish them further by giving them a penalty they couldn't afford to pay?
Well, as currently, they would just go before a judge. So I say just go before a judge, roll the dice, and have fun.
So for clarity, if you just go with the judge and you're found guilty, you don't get the 500. If you say, I want to go a full jury trial, and that's only the crimes, the newer, lower level of crimes that you're proposing, you'd have to pay the $500 because you opted to have the jury impaneled and everything instead of just taking the judge.
Yeah, I don't want people, some of the homeless people urinating in public, drawing stuff out just for the hell. That's what I'm trying to avoid. It was more just to say, as everyone should understand by now, I'm more on the political kick of things where I think that we need to be challenging some of the violations of our rights more aggressively. And this is to aid and support that. Its future further testimony will elucidate.
Thank you.
Yeah.
Seeing no further questions, thank you for your testimony. The chair calls Mr. Staples.
Thank you. I'm here to support this bill. I was arrested 7 times through COVID, a couple times with Gerhardt. I was the one who organized the candlelight vigil out in front of Sununu's, which many of you may have seen. There was a newspaper article about malicious prosecution that 6 people are suing the estate of one of the officers who wrote the tickets. She died suddenly, very much likely from the jab. And they're suing Trooper Dodds, who received guidance from the Attorney General at the time, which was Gordon MacDonald. He's the one who coached these state police and town officers on how to charge and arrest and how to enforce the town ordinance that was created out of thin air by Michael Sununu. And if you haven't seen all the videos about this, I have all the videos on this. I have the testimony from Dodds, all on video. So I've also represented myself pro se, on all these cases. It's found not guilty on most of them. Some of the charges were dropped. The stickers on City Hall were dropped. I then went and put stickers on, before the charges were dropped, I put stickers on City Hall the police station in Manchester. And they're removable stickers. The officer testified that she peeled them right off. She didn't have to call maintenance to take them down or anything. And I was still found guilty. And I was not able to appeal de novo to a jury trial, which I would have been able to do for any other crime. Right? For violations and Class B misdemeanors, you're not allowed to get that de novo thing. So that's already a thing to go from one to the other. The whole $500 administrative fee or whatever that is. I don't know if that's necessary or if that's too much, because currently how it is, you have to appeal direct to the Supreme Court. And that process is expensive. It's, many hundreds of dollars, and that is very difficult. I would have to agree with Rep. Sillig with what she said on that. And to touch on the $5,000 for attorney fees, that's also for self-representation, because you can seek reasonable attorney fees for self-representation, right? And that would assure that people who do that and who do win these things, like I said, I've had multiple victories and not guilty verdicts on my pro se defenses. And then I've had some that, I was found guilty, like with the woman who was arrested for saying amen, Therese Grinnell, at the executive council meeting for the 72 million. You guys all remember that, of course. That was orchestrated by Governor Sununu and the state police to target us for shutting down the previous executive council meeting. Okay, I did nothing that day. I was found not guilty on being arrested for allegedly saying yeah to Teresa's amen. I was found not guilty, but then I was found guilty behind the curtain once I was already in handcuffs for protesting my arrest. And we have the prosecution saying that you can't protest your arrest. There's no statute, there's no constitutional right to protest your arrest, which is absolutely absurd. Okay, so I do agree with Rep. Gerhard here with these malicious prosecutions that are happening for simple things like filming in court, candlelight vigil out in front of the governor's house, and saying amen, right? So I would have loved to have been able to have a jury trial on these things, as is ensured to me by the state constitution. There's nowhere in the state constitution that says, oh, if it's a small violation or a minor crime, you don't get a jury trial. So I would say this would get us in line with the state constitution. Maybe it needs to be edited a little bit with the fine thing or the administrative fee, but I think this is important to recognize the overreach by the state here and the weaponization of these statutes and the criminal mischief thing and disorderly conduct catch-all. Everything is disorderly conduct. I was arrested in front of Sununu's house for asking the cop what he wanted me to stop doing. Said, stop. If you don't stop, you'll be arrested. If I don't stop what, sir? I'm under arrest for asking if I don't stop what. And those cases are still, I have to file a Rule 11 petition in the Supreme Court because the two judges on the two guilties that I did get, the judges refuse to write a written decision. How am I supposed to file a brief in the courts without a written decision on the merits? It needs to be there, Rule 27A, and the judges blatantly say, oh, he doesn't understand Rule 27A, even though it says right in there it has to be a written decision. So I digress a little bit, but I do agree with this. I think it would be, constitutional. Thank you.
Representative Reed.
Thank you, Mr. Chairman. I understand, what you and Representative Gerhard are saying, but my confusion comes, where's the videotaping part fit in?
It's proof of all of the tyranny that we've been dealing with through COVID in this fake lockdown, okay? I have evidence of Sununu texting the state police to organize our arrests. It has to do with the weaponization of the government and the state police by politicians. That's what it has to do with.
I don't know if that's what she was at. Is that what you were asking, or were you talking about?
If you want to see the videos, you can go to Absolute Defiance. That's all right there.
No, I actually follow you on YouTube. We saw it.
Thank you.
What she's asking you, though, is you said arrested for videotaping in court, I think, correct?
Oh, yeah. So the federal courthouse thing, that's a federal thing, so it's a little bit different, but there is concurrent jurisdiction. But there in the Supreme Court, I have a whole playlist of audits that I did. I went there because I got hung up on by the clerk, and I had to go there, and I'm filming, and they're hitting the panic alarm because I have this camera in my hand. And they got the state police coming there, and there is no law. There is a policy amongst all of the courts that comes from Timothy Gudis. It is a Supreme Court order. It's not even from a judge. There's no docket number on it. It's from the clerk, Timothy Gudis, that says that we're not allowed to film in the court, even though we are allowed to film in the court, and they're prohibiting us from filming in the public. I think that bill is coming up today, right? So I'll testify more on that for sure. Definitely.
I see. Thank you.
Sorry. Thank you.
Seeing no further questions, thank you for your testimony.
Thank you.
Does anyone else wishing to testify on this bill who hasn't testified yet? Seeing none, I close the public hearing on HB 1404 and open the public hearing on HB 1438 at, oh, where I am jumping the gun again. 15-minute recess. I just like rolling.
I know. I wish I could, but you think if I saw them early, we would get on that.
Okay, I'm opening the public hearing on HB 1438.
Morning, committee. Jason Gerhard, Franklin Northfield, Merrimack 25. This bill is extremely simple. It simply prevents whistleblowers from being harassed in this state by state officials, but also prohibiting federal officials from carrying out basically black bagging and extradition attempts against them. My feeling is that if we have any desire to return this government to somewhat some stability at all, I think we need whistleblowers to feel that they can come forward and bring forth the truth of what's actually occurring behind closed doors, because that's how we receive most of the most important information. I'm thinking Edward Snowden, Julian Assange, many others who are rotting in prison or have to flee to Russia. I just think that it's important for people to realize that there is a place they can go. The Live Free or Die state would be an excellent choice, where they can bring forth evidence of corruption, fraud, or everything else before the people, and then we can try to rectify it. Instead of having these people fear for their lives and their livelihoods, it's kind of simple, and I don't know. I don't really think there's much to say. I just think we need whistleblowers to come forward, and the best way to do that is to have them know that they'll be safe if they do so. So, take any questions.
Representative Muse.
You've defined whistleblowers, but I know we already have a statute that protects public employees who are whistleblowers. Who exactly is this statute designed to protect?
I'm more thinking people that are bringing evidence against the federal government or other entities higher than that. Not necessarily state level people, but people that have to escape to Russia. Let's put it that way.
Follow?
Follow up.
Your mic's off, Mike.
Mike?
How exactly do those folks qualify as whistleblowers? Aren't whistleblowers people kind of on the inside?
We're talking about people, let's say, like Edward Snowden.
So, for example, for clarity, someone who comes across some information that could be embarrassing to a public official and they wish to share it, you are saying they should be given whistleblower
Well,
protection.
traditionally, what we would call journalists, the ones that actually do real journalism, that produce documents, that publish documents that the government may not want to have released, but they claim that they're national security secrets. It'd be at the Pentagon Papers back in the 70s, or, I mean, there's multiple examples, but it's just recently there's been some attempt to claim that any government documents that they don't want released violate the Espionage Act of whatever 1914 or some nonsense. You know what I mean? I'm trying to just eliminate all that, and just, if you have the truth, it needs to come out, because obviously the government's not doing what it's supposed to be doing, or we wouldn't have all the problems that we have. So that's kind of where I'm going with this.
Thank you.
Thank you. Representative, I'm looking at paragraph 2.
Yes.
It says it would be a Class B felony for any civilian state employee to knowingly cooperate or assist with any attempt by law enforcement to detain, arrest, or prosecute a whistleblower. It doesn't say detain, arrest, or prosecute for what. So that would make it a crime for someone to, for example, be a witness against someone if they committed a crime. It's not limited to just their whistleblowing acts that they're protecting. It's kind of broad. I'm just pointing that out. I don't know if that was your intent, but
No, but I mean, what would stop a nefarious entity from just making up a crime against somebody just to get them out of the way because they are a whistleblower?
no, I meant, for example, let's say it says a civilian state employee. So say our assistant and a whistleblower was here and the whistleblower assaulted somebody and he witnessed it. He would be unable to assist in that prosecution because he witnessed that crime. I'm not saying that they are going after them for some other type of thing. I'm saying he's a direct witness. He wouldn't be able to testify if this were to become law. It's my reading of it.
I see what you're saying. It makes sense. Maybe something along the lines of, unless that whistleblower was to commit a common law offense, just so you don't have some kind of, tail light out or something. So
No, thank you. Any further questions? Representative Newell.
Thank you, Mr. Chair, and thanks for taking my question. Line 10, it says, it is a Class B felony for any civilian state employee to harass with intent to alarm any whistleblower. I was just wondering if you could define that a little more clearly, what it means to alarm.
I think more or less harassed to the point where they don't want to go forth with what they're doing. Like, you know, we can change it. Like, I'm open to suggestions.
Thanks.
Any further questions? Seeing none, thank you. For
All
your
right, thank you very
testimony.
much.
Is there anyone else? Anyone else wishing to testify on this bill? Seeing none, I close the public hearing on HB 1438, and we will reconvene for HB 1445 at 11. The public hearing on HB 1455.
Good morning, once again. Jason Gerhard, Franklin Northfield, Merrimack 25. This bill would provide that the public is allowed to videotape, audio record, and so forth in any publicly accessible area of any public building or on any public land wherein the state of New Hampshire maintains either exclusive or concurrent jurisdiction. So that last part is important. So put that in your notes. So there's a penalty associated with this, and it steps up if you do it multiple times. So the reason exclusive or concurrent jurisdiction is important is because this bill is specifically aimed towards the federal court system, because somebody that will testify after me has already done this at the state, within the state courts, and they're generally complying with the law at this time. There's some holdouts here and there, but RSA 123.1, jurisdiction over lands acquired, states ceded to the United States. Jurisdiction is ceded to the United States of America over all lands within this state, now or hereafter exclusively owned by the United States, and used as sites for post offices, custom houses, military air bases, military installations, or other public buildings, provided that an accurate description and plan of the lands so owned and occupied, verified by the oath of some officer of the United States, having knowledge of all the facts, shall be filed with the Secretary of this state, and provided further that this session is upon the express condition that the state of New Hampshire shall retain concurrent jurisdiction with the United States in and over all such lands so far that all civil and criminal process issuing under the authority of this state may be executed on the said lands and in any building now or hereafter erected thereon in the same way and with the same effect as if this statute had not been enacted. And that exclusive jurisdiction shall revert to and revest in this state whenever the lands shall cease to be the property of the United States. So let me back up a little bit. Recently, actually September 11th, me and somebody that'll testify after me were arrested at the federal courthouse in Concord for videotaping in the lobby. Inside the lobby, it even has a plaque on there saying it's a public building, but Department of Homeland Security decided that that's not going to fly. So they arrested us and charged us under, well, it'll be discussed further. It's a CFR that has no penalty associated with it. The whole thing is kind of fishy. But beforehand, on the Friday before, it was a Monday, but the Friday before, we spoke with DHS and kind of let them know what was going to go on. I'm not trying to surprise the cops. The whole point is to get arrested, civil disobedience 101. So I explained to the cops, the DHS, I should say, that state law, another state law for you, obstructing government administration, 642:1, a person is guilty of a misdemeanor if that person uses intimidation, actual or threatened force or violence, simulated legal process, or engages in any other unlawful conduct with a purpose to hinder or interfere with a public servant as defined in RSA 640:2, performing or purporting to perform an official function or to retaliate for the performance or purported performance of such function. And then in 642, to define public servant means part 2, section A. Public servant means any officer or employee of the state or any political subdivision thereof, including judges, legislators, consultant jurors, and other persons, etc. So I explained to them that I was operating as such an individual and that I had the right to record that because New Hampshire has concurrent jurisdiction within that building. And that is why I brought this bill forward, was to clarify that New Hampshire never gave away their concurrent jurisdiction. And further, I didn't submit this, but we can get this from the Secretary of State. I have a gold seal certificate. The federal government has never complied with RSA 123.1. So they don't even file the papers. And so you can even argue that they don't even have, we actually have exclusive, we didn't even surrender that aspect to it. But the point being is the bill, getting back to the bill, is to rectify the situation where we have supposed public buildings that are off limits to people recording, because certain people, as you'll hear further later on, if you have somebody that has memory issues or any other kind of developmental issues or whatever it may be, they may not be able to remember everything that a judge tells them in a court hearing. I don't know if anybody's gone to trial, especially in federal court. Things get weird fast. A lot happens. So the ability to record and document what is occurring is critical to be able to preserve your rights, because if you don't raise something, you waive it, and then you're pretty much up the creek. There's also the issue of stenographers and hoping that the court actually records what was said and done. And there's many anecdotal stories about that not occurring. So that's the basic gist and concept behind this, is simply to reestablish New Hampshire's concurrent jurisdiction within federal lands that the federal government maintains concurrent jurisdiction over, not exclusive. And yeah, so it's a state sovereignty issue as well.
Yeah, a second. So, couple questions. The state has concurrent jurisdiction, and according to what you're saying, for example, with military installations. The military clearly has the ability to say, okay, you can't videotape here, national security issues. Who do you think gets to decide then which places are and are not? For example, I know the Supreme Court doesn't allow videotapes. That's why we have to look at those sketches all the time. So who is the final arbiter of what should be a secure zone and what not? I assume the Homeland Security is saying this is a security area for whatever purposes. So who would be able to decide?
I think it would have to just revert back to common sense. If a building says it's a public building, I mean, the whole idea of having trials is so the public can see that justice is being carried out and to eliminate vigilantism. So, yeah.
Okay. Representative Rhodes.
Thank you, Mr. Chairman. I just need some clarification from you, Representative. Is this specifically just talking about, courthouses, or would this also be, like an elementary school that's considered a public building?
I believe schools are already covered under public buildings, and you can record there, as far as I understand. I mean, now with kids, that gets weird, and I understand there's some restrictions. As far as in the particulars of it, I don't really know where that line starts and stops. So I'm not going to lie to you on that. The underage aspect of things, like recording in schools, I don't really know where that line is. So I'm not going to argue. My main concern on this is the federal courthouse. So just to let you know where I'm going with this is not to, creep at preschools. I mean, I have no interest in that. So
just for clarification, if I may.
I believe there's already a statute that covers that separately.
Okay.
I just wanted to clarify that your intention of this is court.
My intention of this is reasserting state sovereignty. Yes.
For courts. Yeah.
Thank you.
Representative Muse.
As I read your bill, it looks like this would actually allow people to trail other people into bathrooms in public buildings. Is that true?
I mean, what would stop somebody from doing that to me right now if I go to the bathroom?
Thank you.
Right to privacy.
Yeah, I think it comes
Right
down
to
to
privacy.
questions of expectation of privacy.
Yeah.
And that would be.
I mean, I just want to make this clear. I'm not a lawyer, never claimed to be. Yeah.
Gotcha. Got it. All right. Seeing no further questions, thank you. Oh, sorry, who had one? Oh, Representative Bolden.
Thank you for taking my question. Are you aware of, or did you take into consideration the New Hampshire court rules that require courts to record all proceedings in audio format and maintain those files should a participant in a proceeding request a copy?
I was not aware of that. I don't believe I have to look into that before I say that's true, because state courts. Okay, again, this is more aimed at the federal aspect, but public transparency in the courts, it should be just a sacrosanct principle that there should be no argument over. It's just
Representative Sitek.
You said in your testimony that the federal government has not yet given some of these plans to the Secretary of State.
None of them.
What, do you have any realistic expectation that this would actually be done or observed by the federal government?
You're referencing RSA 123.1?
I'm referencing your remarks. You had, I'm talking about anything you try to do to restrict or modify the behavior of the federal government.
Uh-huh.
If you, based on what you said, if there's a sign in a federal building that says no videotaping, and you're going to claim concurrent jurisdiction, I just don't see it happening.
It
on
did
that
happen.
basis.
It already did happen on September 11th. I did it.
I think what he's asking you is, do you have an expectation that if we pass this law and the governor signed it, that the federal government would pay any attention to it whatsoever?
Yes. It's civil disobedience. You keep on getting arrested until they just have to deal with it. Certain things come down to will. And I don't believe that the federal government has that kind of will to violate a state sovereignty that explicitly, especially, yeah, I'm willing to take this to the end zone. Yeah.
Thank you. Representative Newell.
Thank you, and thank you for taking my question. The situation that you're describing would be if someone wanted to, for their own protection, record a situation where, their case, their court case. But is there anything limiting this, someone using that against someone who did not want their case? Like they don't, according to this, it doesn't seem they necessarily need to be the person who is on trial. So this could be used, in my opinion, it could be used in a malicious way to record someone else's trial who wouldn't want that to be the case. Am I right?
Well, yeah, we could have used this to record Ghislaine Maxwell's trial. Public trial, I think the public needs to know what's going on. Federal dollars are being spent for a purpose. Your tax dollars, I think you should know who and why they're prosecuting people. Does that make any sense?
Yeah, sorry, follow. Yes, I see what you're saying. I just, what I'm thinking about is situations where it's a vulnerable individual or someone who could be harassed in that way. So that's what I'm envisioning as a kind of sad byproduct.
And for
of it.
clarification, the court has the ability to close certain hearings to the public, which would theoretically bar someone from videotaping in that hearing. For example, children or things of that nature, juveniles.
Thank you.
Okay, thank. See, go ahead.
Thanks for taking another question. I think that raises a good point. How do you believe your legislation here would affect family courts that, for example, are permitted to bar people attending the hearing from even speaking publicly about the contents of the hearing? And I think it's like a misdemeanor if like you attend a family court hearing that's under such a condition, and if you reveal any aspect of that communication or what happened, like how would this interact with that?
Representative, you asking about like a gag order?
It's not a gag order. It's I think it's like an automatic thing where if it's a particular type of hearing,
Okay, so
no one who's attended or participated in it
May
can
speak about
even
it.
speak to it. You can't even tell like your mom how it went,
okay.
or it's a misdemeanor. How would this interact with that?
First off, if the state is bringing charges against you, the idea that you can't speak about that situation, that's the Patriot Act kind of nonsense that we kind of accepted, which is absurd. But getting back to what you're saying, I think it's important there's different types of courts. So the true courts, they're under the judiciary. They're not these, hopefully further testimony will explain this better. But some of these courts are created by the legislature, and they're not necessarily true courts in a sense of, let's say, like a constitutional Article 3 court, federal court. They're operating under procedures that don't fully align with the Constitution because they're enforcing regulations versus actual statute, if that makes sense. Maybe I'm misspeaking, and I'll have to clarify. Hopefully we have somebody coming up again who kind of clarifies more so. But again, I'll just say if we wanted to alter this just to eliminate any of those kind of issues, if you wanted to just modify this just to federal court, I'd be more than happy, and I think it gets the point of what we're trying to get across. But one last thing on that point. Again, if the state is bringing charges against somebody, I think it's important for the taxpayers to realize what's being done. I mean, as we heard on the floor the other day, a certain representative was being dragged through the department, DCYF courts for giving his child medication. I mean, yeah, I think we need to kind of figure out what the bureaucrats are doing on our behalf, which apparently is not on our behalf. So,
Thank you. No further questions. Thank you. The chair calls Natch Graves. Oh, I know him.
Thank you, Mr. Chair. Nate Grace for the Municipal Association. We do oppose this bill. Based on the testimony of the sponsor, it sounds like his intent is really to narrow this to federal courts. We would have no opinion on that, but as written, the language is very broad. It would allow recording in any publicly accessible area of any public building wherein the state of New Hampshire maintains either exclusive or concurrent jurisdiction. I understand he referenced a specific state statute. Obviously, municipalities are subdivisions of the state. Presumably, there's some sort of jurisdiction over our property along with the state. So our concern here is really this language is very broad. Anything that's publicly accessible in any public building. And this modifies not only the wiretapping statute, but also the right to know law. And, you know, municipalities are perfectly fine with things like the First Amendment audits and all of those recordings that happen. Those happen quite frequently at many of your municipalities. But we are concerned about what any publicly accessible area means. So, for example, and I'm sorry, but Representative Muse, you sort of stole my thunder here. We are in the LOB right now. This is clearly a publicly accessible building. Clearly, the state has jurisdiction over it. It's, you know, the bathroom is a publicly accessible area. We don't want situations where people are recording the bathroom because that's going to result in further crimes occurring, and we would like to discourage those from occurring. So if this bill could be refined in such a way that it really targets what the sponsor wants, that would be our preference. I'm happy to take any questions the committee has.
Thank you. With regard to your concerns about restrooms and things of that nature, hasn't the court already kind of defined where someone has a reasonable expectation of privacy?
Well, that's under the context of the currently existing statutory language. This would add new language in there. I don't wear a black robe, so I couldn't tell you how the court may interpret that.
Okay. All right, thank you. So to be clear, the association, if the bill were limited and targeted at the federal, you have no opinion on the bill?
I have no opinion on that.
Thank you. Representative Sitek.
Can you give me, apart from lavatories, can you give me an example of a publicly accessible place that that a person could not tape, could not video record? You said it's overly broad. I'd like an example of where you.
Right. So, there are, locker rooms are a good example. I heard someone shout out, things where you might expect people to have some sort of privacy, even though it's publicly accessible. That's really what we're concerned about. We're not concerned about, the lobby of the town hall, because we all know you can record there if you want.
And so if I wanted to, for example, go to a town hall or the health department, and I wanted to walk through the halls and just videotape, that you're okay with that?
As long as it's publicly accessible. I mean, if you go to a town hall, typically there's a public area and a non-public area. So, for example, the town clerks in some town halls are a little walled off because that's where their office is. They have, their accounting and everything else. You can't allow the public back there because people are trying to work, trying to do their thing. But if somebody wants to stand in front of the town clerk's window and record all day, they're allowed to do that. We've seen that in municipalities across the state.
Okay, thank you. A couple of, I'm a fan of some of those interesting First Amendment audio videos, so I always makes for a good debate. Representative Rhodes.
Thank you, Mr. Chairman. If you have, say, an employee of a public building and they were having what they thought was a private conversation, say with human resources, is that considered, would that still be considered to be private, or is that not private because it's a public building?
So again, I think there's a distinction between what's a publicly accessible space and what's not. typically human resource offices are behind lock and key because they have employee files and there's an intense level of privacy associated with those. They have things like social security numbers that we don't want to be circulated out into the public because that will result in identity theft. So I would expect that in your scenario, that would be a private conversation that would be occurring outside of the publicly accessible area.
Okay, good. Thank you.
So I had just a couple of questions and wanted to get your opinion on a couple of areas associated with public buildings that may or may not fall under this. One would be students recording teachers in classrooms, and the other one would be at polling places, which usually are in public buildings like schools and town halls. Would there be any restrictions at all where people could go if this law was in place?
So I don't represent schools, so I'm not sure what the law is now regarding that recording of students and teachers. So I'd prefer not to comment on that. And for the second part, I'd like to defer to the Secretary of State's office because I know there were several lawsuits about recording and photographs in polling places. I honestly don't remember how those came out, but I'm sure the Secretary does. So I defer to his office on that one.
And just for the interest of saving time, the sponsor has been pretty clear that if this were to pass through our committee, he would hope to see that it was just limited to federal courts to avoid this exact quagmire we're starting to go down. Any further questions? Representative Newman.
Yeah, your association represents municipalities.
Yes.
And so it's not, I mean, this deals with state and state concurrent. Do municipalities have any concurrent buildings like that? Or do you have examples of just what concurrent means? Concurrent?
So that's one of my questions because municipalities are subdivisions of the state. So for example, when I used to work up in Littleton, state police would often use our police department to process people they've arrested. It made sense for them to do that because it was quite a far trip back to Troop F. So it was faster and more convenient for everyone. And they were more likely to get a bail commissioner because we were closer to more people. So I'm not exactly sure what that means. And that's why we were concerned with the language as written.
Thank you.
I believe, just for clarification again, he was reading from the statute that defines concurrent ownership and control between the federal government and the state government, not between the state entities itself. So I think that's what it meant. Yeah, absolutely. Go ahead.
Just about your clarification.
Yeah.
So you have a building where the federal government owns, or the state owns it, but the federal government does some things there, or the federal has, if it's exclusive, it's all federal activity in that building. And if it's concurrent, there could be activity on both parties' parts.
Not necessarily. I believe what the statute says is that land in the state of New Hampshire that is ceded to the federal government to use, for example, for a military base or a federal courthouse, etc., the state of New Hampshire retains concurrent jurisdiction over the land. So the question would be then, who's controlling it at the moment, and can we both control it? And that's the question of being raised.
Thank you.
Yeah. Seeing no further questions, thank you for your testimony.
Thank you, Mr. Chair.
The calls Mr. Staples.
Thank you so much. So a lot of the concerns that have been brought up by the previous gentleman and some of these reps here are misplaced. We can already film anything we can see in public. Okay, you can go to Glick versus Cuniff. It's a 2011 First Circuit case, and it was about the public recording police officers in the course of their duties, but the ruling also applies to all public officials. So filming the Department of Homeland Security when we got arrested at the federal courthouse, the interesting thing is we're hearing about First Amendment auditors and all that. I am not a First Amendment auditor. A lot of people think I am because I record what I do whenever I'm dealing with the state. But the post office has a poster that says you're allowed to film in the lobby. And that's what causes the controversy in a lot of these First Amendment audits. Interestingly enough, there is a poster just like that at the federal courthouse. As Representative Gerhardt said, there's a plaque that says this building is dedicated to the citizens of New Hampshire as a public forum. So right on the plaque, but then the poster says we're allowed to film in the lobby. Says we're allowed to film in the lobby. So why were we ticketed and arrested by Homeland Security, not for filming in the lobby, for disobeying an order? We got arrested and charged for disobeying an order. It's a catch-all that they use to keep us from nullifying unconstitutional acts like this. So we're already allowed to film our public officials in the course of their duties. So why can't we film people at the courthouse in the course of their duties? And if the courts are already filming everything and we can get access to it, but we have to pay for it, why can't I create my own records? That way I don't have to pay for it and I can catch things, and I have caught things. I was actually asked to come down and film in Boston court, and I did that. And I talked to I told the judge, and the judge allowed it, because they actually have a process for asking permission, which is what they try to do here in New Hampshire. We have a similar process where they want you to ask permission. First, they tell you you're not allowed to, but if you press the issue, then they say, oh, well, there's a form to fill out if you do want to film. Oh, there's a form to fill out. Why didn't you tell me that to begin with? Why do I need to ask permission to exercise a constitutional right? I don't. Right? And that's why if you go to my Supreme Court audits here in New Hampshire, where this Rule 19 says you shall be allowed to film in the courts, and you can be limited by the judge in a certain case if it's a juvenile case or something like that. And that is also a kind of a problem, like with this family court, the J.R. Hole thing and all that. He was not allowed to film that. So who knows what happened there? And why can't he film that? And why can't a student start filming something that's going on and be a whistleblower in their school? Whistleblowers don't always have to be somebody that works for the state, right? So why can't the kids film what's going on in their classrooms and then bring it to their parents? Film a teacher or something like that. And why can't a parent film their interactions with the school or a doctor, their doctor, things like that? So the ability to create our own records and be secure in those things is an inherent right. Anywhere we can travel and go in public, I can have a body cam on just like a police officer. Why can only the police and the state create these records, and then we can't even get the body cam footage? What's the point of body cam footage when you can't get it unless there is a physical assault, a physical injury? Doesn't make any sense. So Rule 19 already allows recording in courts, and the stenographers, there is an audio recording, but the stenographers are actually typing what they hear. So there is a human error aspect there as well. And I've seen that in cases that I've had where I get the transcript that you have to pay thousands of dollars for, and then it's been transcribed incorrectly by the stenographer. Okay? And then if I have my own video, I can refute that, correct? If I don't, I can't. So why can't we create our own records? And like I said, they make us pay for those too. And it's a revenue generating scheme. Polling places, we're already allowed to record in polling places. You can't go inside where there's a reasonable expectation of privacy, bathrooms, locker rooms, things like that. I mean, come on, let's get real, people. That's not allowed. That's not what people are trying to do. So I was actually recording at a YDC hearing. And when I left, the prosecutor, when the judge came during a break, the prosecutor came back and said, there is an unrepresented plaintiff, victim from the YDC case here filming. We don't want him or anyone else to be able to film any of these hearings in the future. Why? Why is that? Where's the transparency here? Why can't we record our courts and our public officials? We can. I do it. and they don't arrest me because they know I'm willing to get arrested. But most people do not have the gumption and knowledge that I do to nullify these things and have the courage to get arrested at the drop of a hat. So I'd like to also say that when these things do happen, I mean, I had a 5-day, 13-hour trial for disorderly conduct of saying, yeah, allegedly. I mean, where is the money going for these type of things? So also with the public places, if it's a public place, they have the restricted areas. They have to be, there's a notice. There's always a sign when there's a restricted area. So if there's a restricted area, you cannot film there. It's not a public place. Okay. So just, you can't turn public places into private places just because you don't want people recording there. You can't say, oh, well, it's a limited public forum. It doesn't say limited public forum on the plaque, does it? No, it doesn't. So this does not just apply to the federal courthouse. This 100% applies to anywhere in public. And the penalty, there should be a penalty. They shouldn't be hitting the panic alarm and arresting people. It's embarrassing when you watch the videos of me dealing with these public officials who literally have no clue what they're talking about. It is absolutely embarrassing. And then when they continue to try to perpetuate this unconstitutional, illegal practice, this will nip it in the bud because they're going to have a penalty attached. So why is it whenever there's a law to prohibit the state actors from doing anything, there's no penalty attached? Like with the body cam footage law. Okay, so that is odd and strange to me. And yeah, I think that just about covers it.
Thank you.
If you have any questions.
Any questions? I have a quick one.
Sure.
So you were arrested for videotaping in the courtroom,
Charged with disobeying
the order to not
failure
videotape.
to comply with a lawful order, which was not a lawful order.
Right. And I anticipate, you correct me if I'm wrong, they're actually probably going to use the videotape of you there that they took as evidence against you.
They did not take any evidence. They don't even know if I was recording. He asked
Did
me.
they have security cameras is my
They
question?
do, but they don't have my device. They don't even know if my device was actually recording. They do because I shared the video, but
Yeah.
you know what I mean? They would not know that. They didn't confiscate, and I'm not charged with recording because it says right there I'm allowed to film in the lobby.
Yeah.
And if you watch the video, I didn't disobey anything. He said, "Are you recording? Are you recording?" And I went silent. I didn't say anything. And then he just ends up arresting me. So why are you arresting us for filming, which is supposedly, you're saying it's against, and then you're charging us with something else?
Gotcha. Okay. Thank you. Representative Bolden.
Thanks for taking my question. I've had the misfortune, I guess, of being present in the past for hearing on a protective order, and it was uncomfortable for me just sitting in the pews listening to this person discuss a sex assault that they allege experienced, and going into detail, especially with the judge asking questions to try to, I think, assess the veracity of the claims. So there was an uncomfortable amount of detail, and I can't imagine what it might be like to be the person talking about that stuff, or the person accused of it, especially if I was wrongly accused. Do you have any commentary on how someone might feel if they were on either side of that situation, either wrongly accused or having genuinely suffered a really painful experience, and the possibility that maybe even a stranger could record and publish that conversation in a courtroom, as opposed to maybe just having the comfort of knowing that the conversation kind of stays in the courtroom?
Well, you bring up a good point. It has to do with feelings and emotions. And none of this has anything to do with anything when it comes to rights. Your feelings and your emotions about a certain thing are irrelevant. And I'm not trying to be mean here, but what is the difference between it being very difficult for someone to get up and testify, and it's being recorded by the state, and it's being witnessed by all kinds of people. And there's multiple cameras and audio devices. So what's the difference if there's another one or another one or another one? There is no difference. The difference is that the public gets access to what is happening in our system. It provides transparency. It allows people to say, oh, look at this person making these false claims. Their story is inconsistent. It doesn't even make sense. And then the public can make up their own mind as well. Why are we, trying to hide the truth and what is really going on in society and try to make it like the state is the arbiter of everything that happens? No, you work for us. You work for us. We have the right to film what is happening, whether it's someone it's not about the person who's getting the false accusation and all that. It's about filming the judges in the process. And it's already being recorded. So what is the difference of some media organization or me? It's because you don't like me. Certain people don't like me. And you don't want me to have that information. That's it.
No. Thank you. Thanks.
Thank you.
Next. The chair calls Kate Horgan.
Thank you, Mr. Chair and members of the committee. My name is Kate Horgan. I represent the New Hampshire Association of Counties, which is all the elected and appointed officials in your county government. The association is also opposed to this bill for many similar reasons as the Municipal Association, and would agree if this were amended to be restricted to just federal courts, we would have no position on the bill. I was asked to bring up two potential situations that have not been mentioned yet. One is, you all know, there are 11 county nursing homes. Each county has one. COAS has two. Those are publicly accessible buildings, and those are people's homes. If this were allowed to go through, someone could be recording someone who may not want to be recorded in their own home. The second situation would be our county correctional facilities. They set up rules and procedures around filming to protect not only their residents, but their staffs, and we need to be able to maintain that control. I am happy to answer any questions that the committee has, and I'll conclude my testimony.
Just one more, the same thing I asked previously, clarification if we limited it to federal buildings.
We have no position then.
Thank you. Any questions on the counties? Representative Newman.
Yeah, I just didn't hear what you said the second thing was. Could you just repeat that?
Around the correctional facilities.
Thank you.
Representative Saley. That's all. Thanks.
Thank you.
Lu Kang. I got it backwards, I think.
Hello, ladies and gentlemen. I'd like to just maybe step back a little bit from all the arguing that we've had in the last couple of minutes and think about where our powers are derived from and the delegation of powers that is given to us by the Constitution. So, for example, I'm going to make an analogy here. The police force in Massachusetts can carry firearms that contain more than 10 rounds in their magazines. But they say the people of Massachusetts cannot. Now that's a paradox, and it doesn't make sense because the police officers work for the people. So if the people can't carry 10 rounds, then neither should the police officer. And similarly, if the police officer can carry 15 rounds or more, then that's the power derived from the people. And in the sense of recording and whether or not that may infringe upon rights and privacies of certain persons, either at institutions, nursing homes, or in certain courts and so forth, the real question is, does the state have the power to record that scene? that forum or that place or that public area. And if the state has the power to record that forum, then gosh darn it, so do the people, because we gave the state that power to begin with. The state cannot just record something and keep it from the public and expect that no one else can challenge that. Wherever the state can keep a record, I suggest that we, the people, can keep the same record. That's only fair. Not only is it only fair, it's where the state gets their power from. Also, I think there was a question that I was asked to address by Representative Gerhard regarding the court system. And he wanted to explain the difference between administrative courts and Chapter 3 or Article 3 courts. The distinction between a legislative court or an executive court and a judicial court is that the former two regards rights that extend or arise from the government. For example, a licensing forum, a forum that talks about a medical license, that is a privilege extended to the individual through the government. Therefore, the government has the power to establish its own forum for its adjudication. A tax court, for example, is a legislative court. That is a forum where it is presumed that the taxpayer received remunerations from the government that is now putting them into this forum that they call the tax court. The only court that is actually a judicial court is a court that adjudicates private rights. Article 3 courts are different because they adjudicate the private rights that are recognized by the Constitution. That's a case in Northern Pipeline versus Marathon Pipeline, Supreme Court decision in 1982. Was there anything else you wanted me to address? Okay. Did you have any questions, sir or ma'am? Thank you.
Any further witnesses for this bill? There being none, I hereby close the public hearing on HB 1455 and open the public hearing on HB 15, excuse me, that was 1455. I open the public hearing on HB 1535.
Good morning. Jason Gerhard, Franklin Northfield. I represent Merrimack 25. This bill prohibits mandatory participation in digital identification systems. The short explanation is I'm worried about an increasing social credit type dystopia developing, and this is to kind of nip that all in the bud to prevent national ID, or whatever you want to call it, from being formed, which is, when I was growing up, was always explained as the way that Nazi Germany took over the world, essentially. So that's the big thing to be defeated at any attempt to institute it. What I want to bring your attention to, which unfortunately is not in this copy I have, are the penalties. It's line 18. So F, require, coerce, or compel includes physical violence, threat, intimidation, retaliation, the conditioning of any private or public benefit or care on consent to participation, including employment, promotion, or other employment benefit, or by any means that causes a reasonable person of ordinary susceptibilities to acquiesce to participation when he or she otherwise would not. What I'm concerned about is people that receive public benefits, the most vulnerable in society, being forced into this system. Do you want your EBT card or whatever the state level stuff is, and then being forced to undergo all these kind of digitized identification, biometrics, all that kind of nonsense. I don't want to see that happen, and I'm worried that the people at the bottom rungs of society will acquiesce much faster than others who are self-sufficient and don't need that immediate government assistance to get by through the week. I think the bill is pretty self-explanatory. If there's any questions, I'd be glad to address them.
Yes. So under digital identification, line 8, means a set of digitally captured attributes such as name, date of birth, gender, other personal information combined with credentials that are linked to a unique identifier. Is that not the description or of a driver's license? Or a birth certificate?
Well, birth certificate would be digitized.
They are now. I think that they scan them all in. They're all.
What?
Yeah.
Oh no. All right.
So
We're,
I
we're
believe
getting there faster than I thought.
Yeah.
You're
about 10 years late.
Yeah. All right. Well, we're gonna have to fix that.
Is your intent more of some type of a video or a fingerprint or?
I'm really worried about just connecting the biometrics.
So
with the-
biometrics.
and well, just connecting all of it together to create this national ID that they'll eventually push to get on airplanes and all the rest. Kind of trying to nip all that in the bud to remove New Hampshire from that whole matrix so it falls apart.
So some type of citizen profile that the government would keep.
Because we all know it's going to the credit, social credit score thing. I mean, everybody kind of knows that by now.
All right. So taking the bill in that, from that viewpoint, okay, instead of focusing on the language of 8, looking at it from what it would do if we could craft it that way. I got it. Okay. Further questions? Seeing none, thank you for your testimony. Or did someone have one? No? Okay. Thanks.
Thank you.
Next. The chair calls Frank Staples.
Yeah, I know. Oh, I go. I know, I'm a movie star. So just real quick, couple things. And I don't know if this is in there exactly, but we're already doing a lot of tracking and tracing of people. Sometimes I smoke cigarettes, sometimes I drink alcohol, and I've gone to 7-Eleven, I don't have my ID, and they want to scan this thing so that they now know that I just bought cigarettes and somebody knows where I am. And, maybe bad actors come, maybe somebody hacked the system and now they know where you are and they know what you're buying and they know your patterns and your routines and they have algorithms to track and trace all those type of things and come up with profiles. And are we secure in our persons? Or are we not? Right. So I would also suggest putting something in here to stop that practice of scanning people's IDs. They're getting certain corporations to create a policy when I don't believe there is a state law for that because other places don't do it. They claim it's a state law, but it's not. And this is, a way to do the whole social credit score and say, oh, do you have your Vax Pass? You can't come in without it. And this will be the easy way to ram that thing through. And then where does it stop with the Vax Pass? Did you get your flu pass? Did you get, all these other, whatever else they decide to come up with. And yeah, we need to nip this in the bud and shut this down. They've been trying to do the real ID thing for a while. And are we a sovereign state, as our Constitution says, or not? That is the question.
Questions? Seeing none, thank you.
Thank you.
Any further witnesses who wish to testify on this bill? There being none, I am going to close the public hearing on HB 1535, and we have a 10-minute recess. 1:45. Okay, we're going to open the public hearing on HB 1619, and I invite the sponsor to come introduce this bill.
Thank you, Chairman, members of the committee. Last one for the day. I appreciate your patience. Jason Gerhard, Franklin Northfield, Merrimack 25. So this bill comes from a personal situation. Having a federal felony, I was looking to have my rights restored by the governor because in 607A, it allows for the restoration of your rights. Well, it specifically says that the governor shall issue a certificate restoring them. And I actually, this was a few days ago, I received this, the actual certificate from the governor. So it does actually occur, which is nice to know. Did take a little bit of effort. But the reason this law, I believe, is necessary is because there are certain aspects that are a bit unclear. Specifically, it says in part, well, the old law, it says in part that your core civil liberties shall be restored and you'll suffer no corruption of blood. But it doesn't specifically say the right to bear arms. So this is, I look at this more as a clarification overall for the bill, although there are certain things that are added for people who have finished their sentences. And further testimony will clarify some other points. But we look on page 2, line 10, be able to serve on a jury. And we have the right to vote, which surprisingly is allowed in Vermont and Maine for state prisoners. While they're serving their sentences, they are allowed to vote. Now, addressing that in the fiscal note, I don't know how they came up with these numbers, but we have the Department of Corrections indicates that in order to comply with this bill, 4 additional Administrator 1 positions would be required. 3 positions would be in Concord and 1 would be in Berlin. The positions would act as liaisons between cities and towns and DOC residents in order to register residents to vote, obtain absentee ballots, and facilitate all other elements outlined in the Secretary of State's manual for elections. Okay. So they would also provide voting process education to all residents and issue them, well, they don't know if the DOC issued IDs would be satisfactory, which I don't see why they wouldn't, but either way, they claim that to do so would cost $444,000 the first year, and then it goes to $456,000 in 2027. Unfortunately, I left my paper where I did the math, complicated math over there, but it comes out to be there's around 3,000 inmates in New Hampshire. It comes out to $197 per inmate per year in order to facilitate their ability to vote. So I'm going to write to them and offer to do it for $2 an inmate and make a bunch of money and just send them a letter because I don't understand why this would be that complicated. I actually registered to vote while I was in Stratford County Jail pre-trial back in 2008. I voted for Ron Paul in the primary. But the point being is that it's not complicated. Staff can easily take a picture, send it to local polling authorities, and be done with it. It's this. So I don't know if this was designed to try to, destroy that idea. But anyway, in the New Hampshire State Constitution, it allows all people to vote. So it's simply following in line with the Constitution and also our sister states of Vermont and Maine. Additionally, this, if we look at page 2 at the bottom, line 33, this statute shall be construed to be in accordance with 18 U.S.C. Section 922 G1. This is the Federal Felon in Possession Act, well, law. And I'll reference CRM 1000-1499. I can send the link in the testimony to the committee, but this states, this is from the Department of Justice, a frequently litigated issue under 922 G1 is whether a convicted felon is exempt from the prohibitions of the statute because of a post-conviction restoration of civil rights under state law. In accordance with 18 U.S.C. 921A20, a conviction does not disqualify an individual from possessing firearms if the person convicted has had civil rights restored. And it goes on, and further testimony can go more detailed into this. But what I'm worried about from a personal point of view is with my newly minted certificate from the governor that there'll be some gray area as far as restoration of rights and what that delineates, because the feds already seem to acknowledge it, but it would be helpful for the state law to leave no stone unturned, because it already says that all of your rights are restored. So that's the essence of this as far as I'm concerned, because it goes on additionally to say that on page 2, line 16, right retained by former felons, except as otherwise provided by this chapter or by the Constitution of the state, a person previously convicted of a felony shall not suffer civil death or corruption of blood or sustain loss of civil rights or forfeiture or state of property, but retains all of his or her rights, political, personal, civil, and otherwise, including the right to hold public office or employment, to vote, serve on any jury, the right to keep and bear arms in defense of that person, the person's family, the person's property, and the state. To hold, receive, transfer property, enter into contracts, sue and be sued, and to hold offices of private trust in accordance with law. So that's where I was going with this. Hopefully I kind of got close to it, and I'll take any questions that people may have.
Thank you. If you could, just for clarification, it was my understanding that if you were convicted of a federal crime, only the federal government could restore those rights. Is that incorrect? The state can do it?
Well, it's the feds defer to the states. That's what the release from them was saying under 922G1, which is the felon in possession. So the felon in possession law at the federal level is funky anyway, because it has a 0 to 10 guideline. So it's kind of just how the judge is feeling that day. And to me, it seems absurd that you're exercising a constitutional right, and now you're just rolling the dice and up to a decade. I mean, we're not dinosaurs. A decade's a long time. So I think that this... Okay, getting back to your question, because I totally went off course. The federal position is that it's up to the states to decide if your rights are restored. And if your rights are restored, then the feds will respect that decision.
Okay.
Unless I'm totally missing something, and I'm willing for clarification, but that seems
It was
pretty
just
clear.
my understanding that the states could restore your rights for state crimes. The federal government had to restore your rights, and there was a process to do that through the FBI or the Department of Justice. But I could be incorrect. I will look into it. Thank you. Further questions? Okay, Representative Stone.
Thank you. Thank you for taking my question. So the document you're in possession of now from the governor's office, was that in regards to state charges or federal charges?
I don't have any state charges. Oh, I mean the pending federal court thing, for recording in a public court.
I'm just curious, follow up. I'm just curious how the governor of any state has the authority to nullify anything from the federal level.
Well, yes. So it's actually, the governor is simply restoring your rights under the state, at the state level. So I don't have the previous, oh, here it is. It's actually on the form. So I'll read it to you. In accordance with the provisions of RSA 607A5, this certificate of discharge is being issued to the individual named below in order to memorialize the fact that this individual's rights to vote and to hold any future public office are hereby restored, and the individual suffers no other disability by virtue of his conviction and sentence as otherwise provided by RSA 607A, by the New Hampshire Constitution, or by any other duly enacted law of the state of New Hampshire. Then, which this is not in the law. They seem to add a little caveat. This certificate of discharge does not affect any rights impacted by the individual's conviction. So I'm going to bring this up with the governor because he just simply added this in. It's a protection thing on his part, but that has no basis in the law. So, but to answer your question, that's the I wish I had the actual law in front of me, but it states that if it's a state level offense, you go to the court of conviction to receive your discharge. But if it's federal, you go to the governor, and he shall issue this certificate to restore your rights. Did I answer that kind of?
Thank you.
Okay.
Representative Salig.
Thank you, and thank you for taking my question. I don't have an objection to people who are in prison having their rights to vote restored. What I'm curious about is if, hypothetically, we had, Jim Bob from Maine, who was convicted of murder in New Hampshire, and is therefore in New Hampshire jail prison system as a result.
Yeah.
where, so they're a resident of Maine prior to their conviction, what's the jurisdiction for where they are entitled to vote?
Gotcha. So that's page 3, line 21. A person incarcerated in the state may claim domicile for voting purposes in the municipality where that person has last previously established a fixed and principal residence to which the person intends to return. And that's also how Maine and Vermont do it, because you don't want one, let's say Concord has a prison, so there's a whole bunch of people there. You don't want them now just having that extra block of voting power. It just throws the whole system off, and I'm not in favor of that, unless you guys want, felon Jim Bob being the mayor or something. But
Follow up?
Okay, so if Jim Bob from Maine would then not be eligible for this because Jim Bob wouldn't, if his last place of, well, you said both domicile and residency, which are two different terms based on New Hampshire election law, but where is he eligible to vote? I'm still not clear based on your reading of the rules on here.
okay, I'm a little confused about I have to look into that. But it just says that the last previously established fixed and principal residence. So I mean, I think his last fixed and principal residence would be Maine, and Maine allows state prisoners to vote. So all the more power to him. He can vote in Maine.
Pretty much where you lived when you were arrested is where you could vote, based on the proposed language. Yeah. Yeah. Representative Muse.
Can you just clarify which specific rights the governor has restored to you, and for which offenses, which specific offenses?
It would be my federal felonies, so I can list them if you want real quick. We have conspiracy to commit offenses against the United States, conspiracy, that was the first one, right? And then we have conspiracy to commit offenses, conspiracy to impede officers of the United States from discharging their duties.
Representative Gerhardt, are they listed on the document?
This? No.
Okay, then you don't need to tell us all your.
Well, no, I have no problem with it. It's all political crimes. But the rights that are being restored to you are all your core civil rights, and you suffer no corruption of blood, which somebody explained to me. I didn't know what corruption of blood meant. Apparently it's your heirs. So you don't have any issue with somebody, saying, okay, you can't provide, give this estate to your son or whatever. So.
Or your heirs be punished based on something you did.
Okay.
Yeah, that's sins of the father. Okay. Further questions, Representative Murray.
Thank you, Chairman, and thank you for taking my question. I was just curious. On page 2, at the beginning, it says, when you're serving your sentence, that you temporarily lose your right to serve on a jury. But then underneath on line 16, when it says it's talking about the rights retained, it says serve on a jury there as well. Is that like, I'm just confused by that section. Is it differentiating in those two cases, or it's just about what goes back to the convicted person after?
Well, so at line 1, it's any person serving a sentence for a felony conviction from time of his or her sentence until the final discharge from such sentence shall temporarily lose his or her right to. Then we have line 10, B, serve on a jury. But then underneath, it would be 16. The rights retained by the former felon would be serve on a jury, right to keep and bear arms, and so forth. So simply, when you're in jail, you can't be on a jury, which, I mean, kind of agree with that,
Seeing no further questions, thank you.
Thank you.
Okay. The chair calls Frank Staples.
Thank you so much. As many of you may remember, I actually testified on a other bill about felons' gun rights, and I discussed this RSA 607A as it stands at length. And I was promised a response from the Attorney General about a year ago on my analysis. And Rep. Muse here brings up a good point. Which specific rights are, restored. And if you go to 607A52 with this certificate, I have a problem with the certificate that was filed for Jason Gerhard, Rep. Gerhard. It says, in accordance with the provisions of 607A5, paragraph 2, this certificate of discharge is being issued to the individual named below in order to memorialize the fact that this individual's rights to vote and hold any future public office are hereby restored. That's not actually what this law says. Second here. So it says 607A5, paragraph 2, if the sentence was imposed in another state or in a federal court and the convicted person has similarly been discharged by the appropriate authorities, the governor of this state, upon application and proof of the discharge in such form as the governor may require, shall issue a certificate stating that the rights enumerated in paragraph 1 have been restored to the defendant under the laws of this state. Paragraph 1 says, if the sentence was imposed in this state, the order, certificate, or other instrument of discharge given to a person sentenced for a felony upon his discharge after completion of his sentence or after service under probation or parole shall state that the defendant's rights to vote and hold any future public office of which he was deprived by this chapter are thereby restored, and that he suffers no other disability by virtue of his conviction and sentence, except as otherwise provided by this chapter. The copy of the order shall be filed with the clerk of the court. And this caveat in here at the end, it says this certificate does not affect any rights impacted by the individual's conviction under federal law. Well, we heard testimony today on other bills saying, well, how are we supposed to determine the state to determine federal law? So why is the state trying to determine federal law when we can just go to the federal law right here, this 1435 CRM, this is from the federal government website, 1435, post-conviction restoration of civil rights. Exactly what we're talking about. And this is what I read the last time, verbatim, a frequently litigated issue under 922G1, which is the federal firearms statute. It contains an exemption to who is considered a felon. And the felon is exempt from the prohibitions of this federal statute because of the post-conviction restoration of civil rights under state law. State law. So how is it that this thing says that this restoration of rights does not affect your federal rights when this, you know, it actually does? The feds don't have a process to restore your rights. You have to do it through the state. So they rely on the state restoration, okay, to determine whether or not you're a felon. And they do that by, do you get your 3 core civil rights back? The right to vote, serve on a jury, and hold public office. And if you do get those rights back, you're not considered a felon for purposes of the federal firearms statute. So if the feds are saying that you're not a felon based on the state restoration statute, if we read the 607A on its face now, it does give you back all your rights, but it does not specifically mention the right to serve on a jury, which is why it's been added in there, and the right to keep and bear arms in defense of that person, their family, their property, and the state. And so some of the changes here also have to do with the licensure scheme that they're trying to apply to all people. That would be, you know, the licensure scheme as it stands, in my opinion, is constitutional. It's being applied unconstitutionally when it's being applied to everyone under the sun, that you have to get a license to carry a firearm, which is an offensive right. It's a privilege that you get for being a security guard or a police officer or whatnot. You now have the right to actually use it for offensive purposes, and there's training involved and whatnot. So the average person shouldn't have and does not need a license for any of our rights, right? We have the right to keep and bear arms. So there's a distinction between the bearing of arms and the license requirement. And part of the problem is that a lot of these Second Amendment lawyers are using this as a revenue generating stream through the annulment process, and they're trying to make everyone go through the annulment process to get a license to carry when they don't need that license. We get the right automatically. And here's the thing, whether the governor wrote this or not does not affect the fact that Mr. Gerhard already automatically gets his rights back via statute. And that's also, if you read this post-conviction restoration from the feds, that's if it's given back via statute automatically, you automatically get it, whether or not the clerk files this document like they're supposed to. And we have a problem when people go to the clerk of the court of conviction to get their state certificate of discharge. There's this rigmarole that they send the person to offender records. You got to go to offender records. Then offender records says, no, you got to talk to the clerk. The clerk says you. So they're not actually, it says the clerk shall file this, and the clerks are not filing it. But we did clarify that as well to make it so that it's not a problem, and it recognizes that if the clerk doesn't file it, once someone asks for it to be filed, it needs to be filed. We need to be able to get access and not have to file a writ of mandamus with the Supreme Court to get the clerk to do their job or to get the offender records to do their job, which I've done that for Valley Street for this exact thing to get the certificate of discharge filed, right? So, like I said, there is this federal exemption that relies on the state, and this cannot be reconciled without this bill passing and being clarified of which rights, like Muse says, where isn't it specified? Why isn't it specified that all of our state, it could just say all of our state constitutional rights are hereby restored. You don't even have to put the firearms thing in. But if all our rights are restored, which is kind of what it already says, then why wouldn't it exclude firearms unless it's in there somewhere? And it is not in there anywhere, is it? No. So the license is an offensive privilege, not a right. And we're trying to distinguish between that here. And with as far as the voting in prison thing and jail and whatnot, it's similar to like having to file, people have to file their taxes, right? In jail and prison. There's no liaison or anything like that. You got to do it yourself. Okay, so the onus is on the inmate to register and do these things, and they can do that through their case manager. That is what the case managers are for. Okay, so it's not, we don't need positions to suck up $100,000 for your friend here and your friend there. These four positions for $100,000 each. It's ridiculous. It's being done to either pad somebody's pockets or try to find a reason to not allow that to happen. So let's see here. And it's interesting at the end here where they say the Department of Justice states that it is clear that if this bill would result in any additional costs, it is not clear if this bill would result in any additional cost. The most significant potential cost could be litigation expenses were the legality of this legislation to be challenged relative to 18 USC 922 regarding the right to keep and bear arms. Well, we just went over that 922 relies on the state scheme with this Uniform Act on Status of Convicted Persons. This would just clarify it, and actually I would posit that this would prevent litigation from happening, because what's to say that I, as a former felon, I have all my rights, even though I don't have my certificate of discharge. I'm not on probation. I'm not on parole or anything. I can go get a gun. I can open carry. I can bear arms, right? And then I get arrested for a felony and have to go through that whole process. And then that's some litigation right there. All right. That's what we're trying to avoid here with this bill. And I'm curious as to why the AG has neglected to respond on this. Maybe we need the Supreme Court to come down with an order and clarification on what specific rights are restored and retained by people. I would think it goes without saying, if you understand expressio unius es exclusio alterius principle, legal principle, if you don't know that, you should, because basically all of New Hampshire law is written with that in mind. So you have to read it in a certain way and divine what the law actually says.
Seeing none, thank you for your testimony.
Thank you.
Next. Mrs. Kangley.
Hello, ladies and gentlemen. My name is Kang Lu. I think one of the major confusions that bring up a lot of these issues is our use of words, and specifically the use of the word carry and the word bear. Now, people think that the word carry means you just have something in your hand or you're moving it around in a car, for example. But actually, carry is a very specific legal term. And if you would bear with me, I'm just going to read a couple of United States Supreme Court decisions from McCullough versus Virginia, Williams versus United States, South Carolina versus United States, and United States versus Rabinovitz. And it goes something like this. It's elementary law that every statute is to be read in the light of the Constitution, and every word must have its due force and appropriate meaning, and no word is to be regarded as unnecessary or needlessly added. The Constitution is a written instrument, and as such, its meaning does not alter. When that which it meant when adopted, it means now. And words in the Constitution must be read with a gloss of the experience of those who framed them, and would receive the significance of the experience to which they were addressed, a significance not to be found in the dictionary. The Constitution is therefore not only the supreme law of the land, but it's also a dictionary. And the law is the definition and limitation of power. That's Yik Wo versus the United States. Now, since the legislature cannot invoke the sovereignty of the people to override their will as declared in the Constitution, and the legislature cannot redefine the words in the Constitution from which it alone derives its power to legislate, the words to keep and bear arms, life, liberty, private property, house, personal effects, etc., speak to those rights and properties which are beyond the constitutional power of the legislature to reach. Now let's take that in context with the word carry. Specifically, we look at the early founding documents like the United States Constitution and even the Massachusetts Constitution. In the United States Constitution, the word carry means to carry into execution the foregoing powers. And in the Massachusetts Constitution, it's mentioned about 5 or 6 times. And it means to carry out legal obligations, to carry law into effect, to carry on the powers and duties of public officers, carry on the Constitution, and to carry out the will of the people. In other words, the word carry means a duty or power of government. And that's true no matter if you look at the Constitution or if you look at the statutes which are written for the word carry. For example, police officers have a duty to carry firearms. It's a duty and power. You can carry on a business. You can carry on the performance of their duties with a firearm. So what I'm reaching here is that felons, whether they, as soon as they've left prison, as soon as they've left their confines of incarceration, they are by definition restored of those rights which are given to them by God and protected by the Constitution. Because even a felon who may have done something wrong in the past, they don't deserve to be left vulnerable. As you may know, the Supreme Court in DeShaney versus Winnebago says that the state has no affirmative duty to protect citizens, but it cannot take away the ability of that citizen to defend himself. And obviously, when you deprive a man of his right to bear arms, you've done that. And I think the bill in this case wants to codify the restoration of that right, the right to keep and bear arms. And that's distinguished from the entitlement to carry a firearm in the performance of duties or for hire. And I wanted to make that distinction clear because it was alluded to by the previous speaker as well. Does anyone have any questions?
Representative Harry Guthrie.
Thank you for taking my question. You alluded to some cases from different states. Do you have anything from New Hampshire?
The cases which I alluded to were Supreme Court decisions,
Okay.
and therefore they do apply to New Hampshire.
Thank you.
See no further questions? Oh, Representative Peru.
So if you're out on parole, does this kick in? Or
No.
do you have to complete your whole sentence?
It's my understanding that if you're on parole, then in essence, the state has protective powers over you because they have custody powers over you, right? Because they have custody, they have to have the duty of protection, and therefore, in theory, you're being protected by the state, and therefore, you do not have the right to defend yourself.
Okay.
That's the constitutional analysis.
That's what I thought. I just wanted to make sure that was.
Yeah.
Representative Bolden.
I'm sorry. I raised my hand too quickly, but I could have sworn that somewhere in existing law it specifies that if you're on parole or probation, it is considered having served your time. Does anyone else see that? And I just can you repeat that? Oh, on page 1.
Yeah, you're talking about the bill, though. She's asking about existing statute.
Oh, yeah. So do you have any commentary, I guess, on it's 26 and 27 of the first page of the legislation, where it states any person who's on probation or parole shall be considered to be fully discharged?
That was already existing in the law. It already says that.
I mean, in light of your most recent comments. Thank you.
It says any person who is on probation or parole shall be considered to be finally discharged for the purposes of this chapter. I have no opinion on that because I didn't write that. I believe it's already in the statute. Is that correct?
If you're on probation or parole,
Yeah.
they can limit you from possessing weapons.
Right.
That's
Yeah.
it.
Yeah.
Yeah, it's under the federal law. It's not considered wrapped up until you're wrapped up. Okay, thank you. Thank you. No
Thank
further-
you, sir.
The state, excuse me, the state. The chair calls Jeff White and Jane Fireham.
Good afternoon, representatives. Thank you for allowing me to speak. My name is Jeff White. I am with the Department of Corrections as the Director of the Division of Field Services, overseeing probation, parole, victim services, and collections. I'm here to speak to you today about the House Bill 1619 FN, relative to the status of convicted persons. The Department of Corrections is opposed to the bill for several reasons, but most importantly, it's due to the increased safety risks it poses to our probation parole officers. The legislation in question would allow for individuals who are under supervision through probation or parole to have the right to carry a firearm.
It's in the bill.
It's in the bill, line 2627. The department's probation and parole officers routinely enter homes of individuals on supervision, which is inherently risky undertaking anyways. If an individual under supervision is given the right to carry firearms, an already risky situation could become exponentially more dangerous. This scenario would be untenable and will lead to more adverse outcome for our officers, up to and including the risk of death. It's important to note that convicted felons is determined by the judicial system to have previously violated felony level laws and exhibit impaired judgment. Additionally, the department will require additional funding for 4 administrators for positions to be added for us to comply with this bill. 3 of these positions would be located in Concord, 1 would be located in Berlin. These positions would act as liaisons between cities, towns, and departments of corrections residents in order to register residents to vote, obtain absentee ballots, and to facilitate all the other elements as outlined in the New Hampshire Secretary of State's Manual of Procedures for State Elections. These Administrator 1 positions would also provide voting process education to all residents. Currently, residents only possess DOC-issued identification, and it is unclear if this identification would be acceptable to register to vote. The department has many residents whose last known address are out of state, and residents who are part of the Interstate Compact Program who would need to be registered to vote in New Hampshire. I would like to thank the committee for giving me the opportunity to testify today, and I'm happy to take any questions.
Thank you. Did you want to add anything, Ms. Graham? Or? No. Okay, thank you. Representative Newell?
Thank you, Mr. Chair, and thank you for taking my question. Not to give any opinion on the overall bill, but it just concerns me a little bit, people being out on probation or parole, that they would still be considered dangerous. And I was wondering if you could speak a little bit more to that, because I would think that they wouldn't be released if they were.
They are inherently dangerous. We are trying to rehabilitate. Part of supervision, being on probation or parole, is to continue that rehabilitation process, to reintegrate them, and to ensure they're in complying with the conditions of release. The argument that was given about a discharge of sentence, and that would include probation and parole being discharged upon release from prison, to me is ludicrous. The judge orders a sentence of you are sentenced to this much time in prison, followed by this much time on probation or parole. The judge does not sentence to just prison and forget about everything else afterwards. That is part of the sentence. It's not discharged upon release from facility.
Thank you.
Representative Stone?
Thank you, Mr. Chairman. Thank you for taking my question. Generally, when someone's on probation or parole, do they have either a suspended or additional time hanging over their head if they violate the conditions of their probation or parole?
Yes.
Thank you.
On parole, they definitely do, because they're released before the maximum term of their sentence on a regular basis, and they can be sent back in front of the parole board. Okay,
Follow up.
please.
So that would be the utilized term in the industry as conditions of release.
That is correct.
Thank you.
Representative Saley?
Thank you, Mr. Chair. May I ask 2 questions?
Yeah.
Thank you. My first question, and thank you for taking my question, is do you know the rate of
Recidivism.
Yes, thank you for saying that word for me. Particularly for people who have committed what most people would consider violent crimes, or even just generally the rate of
recidivism overall from the last numbers that we had was around 43%, but I can get you the exact number for that.
Thank you.
I would have to see if we would be able to break it down by crime for you. I don't have that.
Okay, thank you. And my second question, and thank you for allowing that, Mr. Chair, is if all of the terms other than the right to vote were withdrawn, I recognize that you have a fiscal concern around that. If everything other than the right to vote and then the fiscal appropriations were made to cover those costs, would you still object to this bill, or would that be?
We would have to look at the final bill. Not obviously our biggest opposition are the safety concerns with firearms. But if we had an appropriation to cover staff that we would be able to carry it out, then we would be able to carry it out.
Questions? Thank you.
Thank you.
Is there anyone else wishing to testify on this bill who hasn't testified on this bill already? Prior to closing the public hearing, I'm appointing a subcommittee on this bill. Representative Stone, Wheeler, Janvrin, and Newell are on the subcommittee. Representative Stone is the chair. 2 weeks, please, on the return. Thank you. And that concludes our business for today. Stone, Wheeler, Janvrin, Newell.
No, he's lying. He's saying
Huh?
he rehabilitates people.
I can't hear you. No. No.
Rehabilitation, nothing.
I could have
Here's what we're putting in here.